Sarah Boone was convicted after trial of the second-degree murder of her partner, George Torres. She said that they had been playing hide and go seek, and she zipped him into a suitcase and then thought he could get out and left him there. And then the next day was like, where is he? And then she testified that she did some things on her computer and then eventually went downstairs and checked on him, and he was still in the suitcase, but no longer living. When the evidence came out at trial, there were some video recordings on her phone. I suspect she, in her intoxicated state the night before, forgot that she had made those recordings, taunting him while he was in the suitcase, zipped in, telling her in heartbreaking videos that he couldn't breathe, and asking her and then begging her to be let out. She represented herself for a period of time during this case. And during the time that she represented herself, she was writing a substantial amount of letters to the court. She wrote an advertisement for a lawyer that actually worked. And her lawyer at trial came in and said, hey, I saw her letter that was covered in the media where she was advertising for an attorney, and she deserves an attorney in this case. So her lawyer like parachuted in and she tried to run a battered spouse defense, saying that this was a reaction to violence against her. The jury did not believe that. Even if it were factually accurate that she was in fear from George Torres at the moment when she zipped him into the suitcase, he had been abated. Like, he was no longer in a point where he was threatening her. And she had a lot of options at that point. Call law enforcement, leave the home and call law enforcement, because he was not getting out of the suitcase and was subdued. And the jury was like, yeah, no, we don't believe that. So her defense did not go the way she thought it was going to go. She still believes, it seems, that she has been wronged by the system, the victim's family, the judge, all of her 9 attorneys, the internet, the media, the keyboard warriors, and everyone else. Why do I know that? Well, she told us at sentencing when she gave a very long lecture about how this was done to her. Today, we are going to take a look at Sarah Boone's latest letter and disagreement. Sarah Boone has been sentenced to life, period. Her appeal has not been filed yet. The attorney that parachuted in is not the attorney for appeal. She has been appointed appellate counsel. She is now on the second, I think, appointed appellate counsel. And she has wrote to the court, July 8th, 2025, State of Florida versus Sarah Boone, notice of inquiry. Comes now Sarah Boone, appellant, and respectfully moves this honorable court to please provide status of her court-appointed appellate attorney, Joshua E. Adams, in addition to her inquiry as to the status of her pending appeal. This was filed with Judge K. It might also have been filed in the appellate court, but I found this filed with Judge K. In support, the appellant states the following. An order was filed with the 9th Judicial Circuit by the Circuit Court, Judge K, appointing appellate counsel on December 18th, 2024. Court-appointed counsel has sent a single basic introduction via inmate messaging on February 27th, 2025, asking if she had any information and to not hesitate to contact him. Appellant has attempted to contact Mr. Adams via inmate messaging 5 times, which actually for her is not a lot, since February, and sent 2 handwritten letters to his office in efforts to receive status of her appeal, and to confirm receipt of her correspondence to ensure his representation was and still is active, from no response from him. As much as Sarah Boone can be a frustrating individual to deal with, where we're at now, I don't find unreasonable. He was appointed in December. It's fucking July. Your lawyer should tell you, this is what's happening. These are the steps I have to go through. This is what's coming next. Between February 27th and July, 5 times, and 2 letters is not a ton, and an update of, I'm gathering all the documents on your appeal. I'm going to write the appellate brief based on the notice of appeal from your other counsel. I will notify you when your appeal is filed. This is going to take me 6 months. I don't think that's an unreasonable request. To the present date of this inquiry, appellant has not received any type of response or correspondence in any form or manner from the attorney, nor has any of her 9 third-party representatives on her behalf via email and phone calls, which go directly to his voicemail. It's not 5 reach outs. If there are 9 other people trying to reach this attorney on her behalf. Here's the problem though. The attorney can't tell them anything, but the attorney should tell her what is going on. Ongoing 7 months, appellant has received 1 message from her court-appointed appellate attorney. Appellant was recently made aware by a third-party representative, that's not how that works, but okay, that the court issued an order on June 13th with a 20-day due date requiring an initial brief or her appeal may be dismissed. Due to the complete lack of proper and effective communication from her court-appointed appellate attorney, the appellant's appeal is now in jeopardy. There's been an extension. The failure of an appointed attorney to perform duties or communicate with their client cannot be held against the appellant. Agreed. If the attorney missed a date, the appellate court would probably make it work, because she has the right to appeal. She also has the right for her attorney to keep her informed of her case. She's not wrong about that. Dismissal of an appeal under these circumstances would be an obvious denial of her due process and effective assistance of counsel. Appellant further invokes Douglas versus California, which guarantees the right to counsel on a first appeal as of right, and Aders versus California, which outlines the duty of appointed appellate counsel to support the appeal or withdraw following proper procedures, neither which have been followed here. I mean, the appellant record seems to be getting filed. Communication with the client seems to be difficult. Appellant respectfully requests this court to please advise and take notice of these violations and to either compel court-appointed appellate attorney Joshua E. Adams to fulfill his legal duties and communicate immediately, or appoint new counsel capable of necessary communication and representation and inclusion of the appellant. It's fair for a client to want to be kept in the loop. Though it seems that Sarah Boone's level of wanting to be kept in the loop is a mismatch with the average attorney-client relationship. There is nothing that Judge K can do to force the attorney to do something. The appellate attorney is not going to respond to this in the trial level court. So if the appellate attorney is like, I have emailed her once a month with a status update, we're not going to know. But the appellate court, if they see a problem, will ask, this is not a problem yet. And appeals take a substantial amount of time. I think telling someone, I will tell you when it's filed, is fair and reasonable. I still don't think that would be satisfactory to Sarah Boone. I think she wants to be kept in the loop more than that. But the amount of work that appellate counsel has to do to prep a brief is substantial. And there's no input they really need from the client because the appellate brief is made on the record. But it should be communicated if it has not been. Are we going to end up with Sarah representing herself on appeal? I don't think she wants to represent herself. I think she wants a lawyer to do her bidding. And I think she wants it to feel like she's in charge of the lawyer. And she's like, no, I want you to argue this. An appointed appellate counsel is going to be like, that's not how this relationship works. So I'm not going to do that. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.